Sir, I have something to say. Number one, the petitioners cannot approbate and reprobate at the same time. They are calling upon the respondents to file their responses. At the same time, they are seeking leave to amend the petitions. How would petitions that are to be amended be responded to when actually it should be the amendments that should come first and then responses follow? Two, we brought to the attention of the petitioners that the interim order, one of the interim orders expires today, and the other one is the one we are complaining about, but it is actually aggrieving the respondents and should be set aside, the Kilowaya order. Therefore, we shall be delving into that as soon as it is practicable. And number three, the reason why we are here and from the day before yesterday is due to the applications that were filed on the 18th of October to set aside the ex parte conservatory orders. Therefore, that agency cannot be lost or cannot be clouded in whatever else they are saying. It is our position that we should actually proceed and be heard on why those conservatory orders should be set aside. Thank you.
I apologize. We are raising so many issues. I do apologize. And we have to be a question. When I made an application for people to say that we can enjoy, my Lord Justice Okora, you are very kind now. You probably allowed my application because the figure was to be done and the altar was to be done by the you have not mentioned if you would be kind enough.
In which petition?
Yeah.
In which one?
Which cohort?
This, I'm sorry, I don't have papers, but this one.
Well, you in your own name?
Yes, in my own name. John M. And of course, it was in
So you are petitioner number 8?
No.
Interested party number 8?
That's all. Thank you very much.
Thank you, my Lord. We just want to restate the position that the urgency in this matter cannot be gainsaid or cannot be lost, my Lord. Under the contention that the replies have not been made, that we have not made the replies, is not correct because we have filed our responses. And my Lord, at the end of the day, the very essence that led to the empanelment of these judges will actually be lost, because then we will be going back and forth, and at the end of the day, my Lord, we will not have served the greater public interest or the greater public good that led to the empanelment, which you made a determination yesterday, my Lord. We would ask that we be able to proceed and argue this matter conclusively and rest it once and for all.
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings. But one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we have all acknowledged that they are public interest proceedings. No party will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We need to do that.
Let me talk.